For those who don't know me, I am Tess Hardy. I'm an associate professor at the law school and I am director of the Centre for Employment and Labour Relations Law. Before we commence, I'd like to acknowledge that we are holding this event both in person and via Zoom, and the event will be recorded. The in-person participants are on the land of the Wurundjeri people of the Kulin Nation, and I'd like to acknowledge their elders past, present and emerging. We have a stellar lineup tonight, so I'm very excited to welcome Professor Paula McDonald from QUT, who's done extensive work over many years on young workers and education to work transitions. We also are joined by Josh Peake, who's the Secretary of SDA in South Australia, who'll be talking about his passion in this area, which I know is very strong and also very long-standing. And our final speaker tonight is Marcus Bongiorno from Wage Inspectorate Victoria, who has, again, had extensive experience in terms of advising on child regulation or the regulation of child work in Victoria, which is in many ways in a unique position, having recently revised their laws and has a very active inspectorate. So we're going to structure today's panel seminar. Each speaker will have time to give a short formal presentation, and then that will be followed by Q&A. So those who are attending via Zoom, please feel free to add any questions or comments you may have in the Q&A function. There's also a chat function available to you if you'd prefer. And one final thing from me is to acknowledge the sponsors of the centre who facilitated the holding of this event. We are very thankful and appreciative of their support for the centre and for these events. So over to you, please, Paula.
Thank you. Okay, so in some work that Andrew Stewart from the University of Adelaide and Tess and I have been doing, we've discussed for a while sort of what we mean by a child and what we mean by a worker. So the child part was fairly easy. We've decided to focus on minors under the age of 18. But when we talk about work, that's a more slippery concept in terms of the way it's been written about in the literature. So we've gone with the term children's work rather than child labour, the latter being a term that generally refers to work sort of outside international legal frameworks and which, according to the ILO, deprives children of their potential and dignity and is harmful to their physical and mental development. We refer to work rather than employment, and I'm sure most people here and online would agree that employment is kind of a subset of the broader term work. And we've sort of settled on this definition, which is activities for payment or profit in a business, trade or occupation. So that can include forms of work in which the child doesn't necessarily get paid, but where there's some sort of ultimate payment or profit involved. And this includes work in traditional employment relationships, like a lot of the children that come under Josh's jurisdiction, but also apprentices and trainees, informal service work outside the child's home, such as babysitting or lawn mowing, things like that. Work in family businesses, and I'll talk a bit about that during the presentation. But if we extend this notion of what we mean by work, we could also think about work as being some emerging forms of work, such as what's increasingly known as kidfluencing. So these are children who perform on social media, either under their own steam or under their, especially if they're under 13, under their parents' social media platform. Or we could even talk about elite child athletes. So at present, there's no Australian or, as far as we know, international legislation around the duration and intensity of training regimes for elite children who participate in elite sports. And they certainly often not monitored by sporting governing bodies, but nonetheless, some of these children are exposed to quite extensive training regimes, and they may be subject to a contractual arrangement similar to adult athletes. We propose not to include in our definition of a child or children's work things like household chores, caring for family members, volunteering in religious or sporting organisations or at schools, and short periods of unpaid work experience. Although, and I won't talk much about this today, but unpaid work experience and internships and volunteering have a kind of slippery relationship with what we usually understand as work. So I'll talk a little bit about what we know from the research on child workers. So overall, there are really quite substantial data sets in relation to how we understand where, when, and how children work. So if we look at that research overall, the research tends to focus on a single work context. It often uses non-representative or undefined samples, so they just talk about young workers without defining an age range. It can often adopt quite short time frames. It often neglects work in some of the unregulated settings, which I mentioned under the definition, and it has failed to develop robust theoretical frameworks or data that can be compared across jurisdictions or longitudinally. Research and policy also refers to transitions from education to work, and I'm somewhat guilty of using that term myself. But this really neglects the reality that for a lot of children, they participate in education and work simultaneously and often for long periods of time, especially when we think of how education trajectories have been extended where children finish high school and then they participate in university or get a vocational qualification. So this is often a long stretch. And of course, the world of work and education has also profoundly changed since many of the older studies that we see in the literature. And so, for example, trading hours have been deregulated, alternative business models such as digital platforms have proliferated, providing more opportunities for young people to participate in work. Employees are often managed and work is organised via a whole raft of new digital technologies. And we've seen a lot of efficiency expectations which have sped up work in many industries. And then if we look at some of the sort of major data collection in Australia, so the ABS collects data on workers 15 and over, but it only reports occupation by the aggregated category of 15 to 24 years. Now, obviously, there's a big difference between what 15 and 16-year-olds are doing in the labour market compared to what 23 and 24-year-olds are, most of whom have been in the workforce for a long time or have completed their education journey. The last ABS study on children under 15 was nearly 20 years ago in 2006. Hilda collects data about work and employment in the 18 to 64 age bracket. The ILO Global Survey of Child Labour Trends actually pointed out fairly recently that it was unable to access any robust or very little robust data about child employment in industrialised countries. And we have seen selected waves of the longitudinal study of Australian youth and longitudinal study of Australian children who have collected questions from time to time about children's work. But it's interesting that the questions are often, they were in the survey, but the answers to those questions don't turn up in the reports. So my only assumption from that is that the data perhaps wasn't considered to be robust enough to report in those successive waves. So basically we've got a pretty rubbish set amount of information on child employment in Australia, and that's replicated across other industrialised countries. So for years now, we've We've seen evidence emerging about exploitative practices in and around child workers. And this is really the sort of rationale about why we need to do more. So children experience higher rates of workplace injuries than adults do. Some estimates have been around 18%, although, and Josh might talk about this, that's probably underestimated because it doesn't include children who work in family businesses and the rates of injuries. And anybody who's had a group of adolescents around their dining room table will know that injuries are pretty common and very underreported. Now, although we do have regulation which restricts children working in obviously hazardous jobs, many work with dangerous equipment such as knives, deep fryers, hot ovens, and particularly in cafes and restaurants. And franchises in particular have attracted criticisms for high rates of injuries. Children are also subject to disproportionate risks of bullying and sexual harassment. The 2022 Australian Human Rights Commission survey found that 60% of young women and 25% of young men aged 15 to 17 had been sexually harassed at work in the last 5 years, and this was the highest proportion of all age categories. And that survey also found that in accommodation and food services, that 17% of those who were sexually harassed were harassed by someone aged 15 to 20, even though only 7% of harassers were in that group. So basically, a lot of children are being harassed by other children and young people. And as we all know, children are often very anxious and reticent to action when they experience sexual harassment and bullying at work. And this, of course, is a result of their age and their lack of seniority and the power imbalances that arise from that. There've also been quite a bit of recent research on wage theft, and I'm sure everybody in the audience is quite familiar about how that plays out. And this, of course, it's interesting that the problem or the disproportionate problem of wage theft amongst young people kind of exacerbates the whole youth wage, junior wage rates that we have in Australia. It's like, you know, I think you'll correct me if I'm wrong, Josh, but I think a 15-year-old gets paid 40% of the adult rate in the hospitality industry, and in some cases, employers can't even pay that. Children also have quite unpredictable work hours and rosters, especially, you know, they're often juggling a lot of things as well. They're juggling assessment at school, sporting obligations, family participation, and so on. And of course, we've seen the recent breaches in Victoria, which I'm sure Marcus will talk about. But we don't know a lot across the board about other kinds of temporally related aspects of children's work. So that includes things like how their rosters or shifts are allocated, the scope they have to refuse work with or without penalty, the periods of notice they receive prior to shifts, the duration of breaks, and the stability and continuity of work hours, all of which can have a negative impact on their education. And these concerns, of course, have been raised repeatedly, but they're exacerbated by the problem of children and their parents, and even some employers not necessarily having a good grasp of the rights and obligations pursuant to children's work. So some shortfalls in state and territory legislation. So in terms of laws that aim, so keeping in mind that in all states, there are general laws that are related to children's education, so children can't attend work while they're meant to be at school. And then in some states, but not South Australia and Tasmania, there are child employment specific laws. But these are really and truly a hodgepodge of rules and regulations or that are either inconsistent or non-existent in relation to things like how work or employment is actually defined, the minimum ages at which children can work, the restrictions on working hours, specified examples of hazardous work, permits, supervision and record keeping, and also how states and territories monitor and enforce penalties. So finally, this is my last slide, and apologies for I probably should have split this, slightly small font. But I think, so these are just some ideas about what I think and what we think is needed. First of all, and of course, I would say, I'm a researcher, so I would say we need more research in this area, but really it is kind of shocking how little substantive, robust and across the board information we have about what children do in the workplace. So I think we need a comprehensive, multi-dimensional, quantitative picture of children's jobs and their workplaces, possibly from a work quality perspective. And we also need some in-depth case studies of children's work environments in some diverse settings, but especially where that workplace is not covered by regulations such as in family businesses, where there's evidence of non-compliance or violations of employment standards, and when there might be specific psychosocial hazards such as in relation to modelling and kidfluencing that I mentioned earlier. And then, of course, we need better, extended and more harmonised legislation. I don't see a lot of political appetite for child employment to be imminently put into the Fair Work Act, but certainly in terms of state and territory legislation, we need better guidelines that address a broader range of work contexts, that removes the blanket extensions for work in family businesses and possibly around work experience as well, that takes into account the profound technological changes that have hit the workplace in the last few years. We need legislation that specifies more detail and consistency around hazardous jobs, that includes provisions for appropriate supervision, and that is resilient to dilution by industry lobbies and interests. And we've seen that recently in Australia with in the retail sector. And there's some pretty shocking proposals that have been put on the table in about 7 US states, I think, that so there's always this push by industry to roll back employment regulation for economic reasons. And then finally, some other sort of, regulation more broadly defined and resources, obviously well-resourced agencies with appropriate powers like the Inspectorate in Victoria that can audit, monitor, issue permits and investigate and prosecute breaches of any acts that are involved. We also need more advocacy and advice and collective representation. With advocacy advice, that's always problematic though, because it entails an individual sort of coming forward with a complaint, which is never a panacea for structural reform. And it's, just a possibility, maybe some national industry codes for employers that set out age-appropriate guidance on processes like induction, record keeping, training, supervision, and then a set of secondary prevention strategies which allow children in workplaces to complain about something that has already happened and that they have a voice and that complaint is appropriately responded to. So I'll leave it there. Sorry if I talk. Sorry if I talk too long. Yeah. I know.
Thanks very much, Paula. That was fantastic. You had a lot to fit in this short amount of time. So over to you, Josh.
All right, well, good evening, everyone. And firstly, Tess, thank you for having me here. It's been something that you're right, I've been very interested in for a very long time, but also continue the work that we've been doing in this space. And it's also great to see you again, Paula, and I look forward to the work that you both, along with Andrew, have been doing, because you are right. Unfortunately, it is difficult to get attention into this space, and we do need it to be led not just by, and I note that Jordan Mumford, who's the chair of the ACTU youth committees here as well, not just led by the union movement, but also the need to have thoughtful contributions to this discussion. Also like to acknowledge that we are, of course, on the lands of the Wurundjeri people and acknowledge their elders past, present and emerging. So a little bit about us and me. So I'm the secretary of the SDA in South Australia. The SDA is the largest union in SA with slightly over 33,000 members. We have, I think, for a very long time had a very strong focus on young people's rights and attempting to organise young people going back decades with a very strong focus on fast food. And the result of that is that over 60% of our members are under the age of 26 and 20% of our members are under the age of 18. One of the things, and I think one of the starting points for this conversation is also, why is this even necessary? Why are we talking about this? Why does it particularly matter? Well, in our experience, and this is backed up by a lot of the comments that Paula said and the research is that, and I think we inherently know this anyway, is that young people are probably one of our most, or if not the most vulnerable groups of workers that we have, or they're probably at very least the biggest vulnerable group of workers that we have within the community. They're vulnerable for some of the reasons we all know about. Firstly, simply their inexperience means that they haven't worked in other workplaces and understood what workplace norms are, not necessarily having a clear understanding of the rights and wrongs of the conditions that they may face. So that lack of experience, I think, is a really key driver of it. Not yet being educated, and one of the things that is a problem with, I think, most states' education systems when it comes to the work readiness training that often occurs is it's really career focused, and you understand why. Governments and the syllabus is very interested in understanding what's someone going to do for their life, what are you going to do when you grow up, conversations. And a lot of the conversations about work in either the business programs or the sort of program that does exist is very much about that, and skips over some of the basic understandings of rights and obligations within the workforce. So knowledge is incredibly low. I think you commented on this before, but very unlikely to speak up about things going on at work. Now, I know that from my personal experience. I came from a pretty aware union household as a young person, but started work like many of us in my first job working in a supermarket, was made on commencement to sign a AWA. There was no choice in that. We just handed it. It was a Australian Workplace Agreement, and I liked my job. It was a good job. Liked working with my mates, but there were a lot of things that went on in that workplace that, as an adult, I know to be completely unacceptable. And I'm not necessarily a shrinking violet. I wasn't as a kid either, but I was scared to speak up about those issues. I remember a particular incident when it's actually the victim and I fell through a ceiling at work with the way they'd stacked their chips on this dock, and was pretty significantly injured from that. No report was made. Nobody did anything about it. I think I was accused by a manager of what did I do to their ceiling, as opposed to being concerned about my bleeding leg. But this is just what work is like for many young people, and that ability, that fear of speaking up, is something that really makes the workforce particularly vulnerable, and that is linked to the power imbalance. There is a natural power imbalance in every workplace between worker and boss. It is so much greater with young people. It is amplified to an enormous degree. Young people, in many cases, are brought up to, we train young people through sport and school and other, and our households to respect authority and follow instruction. And so simply not understanding the rights and wrongs and taking what a manager says. And, we see that in some of the big litigation that our union's involved in, where people were just expected to come into work early. They didn't know they were supposed to be paid for it, work through their breaks because they were given a free soft drink and thought that was just the norm, and didn't know to speak up about it. And of course, all of that sits in a context where we drive an incredibly high level of youth employment in this country, because we have a massive market force, which is the system of junior rates. And so workplaces specifically go out and hire young people, not because they want young people to work for them particularly, but because there's a massive financial advantage in doing so. Paula was right, as low as 40% of the adult rate for a 15-year-old or under in the fast food sector, 45% in retail. But one of the things that people may not also realise is that under 18s don't earn superannuation. So in Australia, to be captured by the superannuation guarantee, you have to work at least 30 hours a week if you're under 18. For everyone else, it's just paid on your ordinary earnings. So if you think about 40% of the adult rate and no super, it's more like 35% of the wage cost of an adult. And so that drives a really high level. And there's quite revealing data from McDonald's, for example, which demonstrate that 60% of their workforce are employed are under the age of 18. Over 80% of their workforce are on some form of junior rate. You walk into a McDonald's in the rest of the world, you don't see the workforce profile you see here, and it's all driven by cost. Some of this framework you've covered, and I'll just sort of think about this, and I just wanted to pose this problem that we do have. We've obviously got the Fair Work Act that governs private sector employment consistently nationally. We've got somewhat, not completely in this state, but somewhat harmonised work health and safety laws nationwide, but we don't have that with child labour laws. And from my perspective, child labour very much sits in between the two. It's about minimum standards and rights for young people, but also making sure that as much as we can through law and regulation, making sure that whilst people are going to get jobs, we want to encourage exposure to the workforce. We want to make sure it's as safe as possible when you're not seeing people having terrible experiences through what is often their first contact with the workforce. Australia ratified the UN Convention on the Rights of the Child in 1990, 35 years ago, and it outlines a number of things that children should be protected from, such as economic exploitation, and I've commented on that slightly a minute ago, hazardous work, and importantly, work that interferes with their education. But despite that ratification over 35 years ago, we haven't really done anything to implement it at a federal level. In very good news, I think as Paula said as well, the federal government last year, or 2 years ago now? June last year, ratified. Only took them 50 years, I've got to say, but 50 years later, the ILO convention, which is one of its fundamental conventions, and we've been a really key member of the ILO since its foundation, but we finally, 50 years later, ratified the minimum age convention. The minimum age convention says that people under 15 shouldn't be doing work or shouldn't be doing anything other than light work, and then the convention goes on to say that people as young as 13 can work, but that work should be light work, and it defines light work as work that is not harmful to child's health and development and doesn't stop their participation in education or vocational training. But again, despite its ratification, we're yet to see a move to some nationally consistent laws in this space. It would require an alteration to the referral of powers, and so that's part of the question here, and I think the federal government is quite reluctant to move in this space, but it's certainly, and one of the things that I do agree upon, and one of the things I'll be commenting on at the end, is that at the very least we think there should be some basic standards that are consistent, just like through the work health and safety law harmonisation. That's all already occurred, and at the very least based on Victoria's, I think, very good standards, although I think only targets the youngest children. It doesn't focus on those 15 and above, which still does cause some problems. So I think covered this. We do not have any standalone or specific child labour legislation in Tasmania or South Australia, but the remainder of the jurisdictions do have some form of legislation, but that doesn't necessarily reflect a minimum working age. So even though New South Wales has got child labour laws, they don't have a minimum working age. You often hear this myth. I mean, many people might know about it, the 14-year and 9-month rule. People say you can't work until you're 14 years and nine months. I've been trying to repeat as often as I can, this is not true. And we think where it came from was that it was a standard in many states as to when you could actually, going back 30 years though, about when you could leave full-time education for full-time work. So the rule was never about a casual job at Macca's or, getting a night field shift at Woolies. It was about when was it that you could leave school permanently to get full-time work elsewhere. And in many jurisdictions, the 14-year and 9-month rule was there, but it's not there anymore. And all states either have 16 or 17 for leaving secondary education. What laws do we have in South Australia, where I'm from? Well, effectively none. We do have one, so that effectively means, I'm sure there'd be other issues but effectively there is no minimum working age in South Australia, and no law that governs any standards upon which children must be employed. So, whether it's 8, 9 or 10, it wouldn't matter. Children can work in a job in South Australia. There is a provision in the Education and Children's Services Act that says you can't be employed during school hours. You can't be employed in a way that impacts your attendance at school. So we say that limits overnight work, for example, and we do a fair bit of enforcement of that. But ongoingly, employers continuing to ignore even those minimum standards. And we've got lots of examples where, kids are being asked to come to work and skip a day at school, where they're working to 2 or 3 a.m. in the morning in fast food, for example, and that clearly impacts on them, or just doing too many hours in a school week to be able to properly attend to their schooling. We did try, I think last time in 2011, to pass child employment laws. They were very bare bones and sat most of the rules that would have come along with them in regulation regardless, and we really haven't seen an attempt to fix it since then. We have been successful in some spaces, so and this is a nationally consistent problem as well, is when it comes to the definition of child-related work and those people that are charged or convicted of child sex offences. So we've been uncovering a reasonably, and it's actually depressing how often it has been revealed to us that this is a problem. But essentially, when people are charged or convicted of some kind of child-related sex offence, they are banned from participating or doing any child-related work. And that's a general rule that exists in different words across the country in different ways, but that's essentially the principle. Nowhere, up until very recently, did child-related work extend to where children were also employees. So child-related work talked about the care of children. So an education setting, even things like, not being able to be involved in certain volunteer settings like scouts or swimming instructors, sports, those sorts of things, but didn't connect through to where you may be either a colleague, but in many cases, a manager of a child, did not cover the definition of child-related work. So this was particularly revealed to us 3 years ago, where we had an individual charged with an offence that continued to manage children in a McDonald's despite being charged with a child-related offence whilst that went through the courts. The courts knew where he worked and nothing was done to stop that ongoing employment. So as of a month or as of a few weeks ago, really South Australia has now, and it's the first jurisdiction to do this. So we've changed the Child Sex Offences Registration Act, and that redefines child-related work to being any workplace which there are children present. So it's a very big definition now, and it does two things. It says that if you're a child sex offender, you cannot work in those workplaces unless you seek an exemption from the Commissioner of Police. If you're charged with a child-related offence, it becomes a bail condition, and it's a question for the magistrate. But we think that's logical. It makes sense. There is still a gap around screening. I know some work's been done in Victoria around the question of screening, which you might go to, but there's still a gap around screening. The onus on compliance with this law is the perpetrator, not the employer. So there is still no screening checks that require the employer to actually check the fact. And so we say that's a gap, and that still needs to be addressed. Our union has a protocol with the South Australian Police, which has us being somewhat of a notifier when they're aware of someone, but they might not know who to contact as the employer. And we will do a lot of work to ensure there's contact between the two, so that employers can be aware when this is the case, to ensure that those people aren't continuing to work in workplaces that also employ kids. Paul has covered all this a lot, but unpaid work is a key problem. We'll go through some of our survey results quickly, but a lot of our members seem to do unpaid, particularly pre and post work, come in early, stay back late, but clock off, work through your breaks, basic working for free issues. Sexual harassment is a big problem. I think you separated it out, 47% is the human rights, I think. If you get
60% of women, 25% of men, 15%.
Yep. Power imbalances, we've talked through bullying, constant shift cancellations, just not being aware of what the rules are around rosters and shifts is a big problem. Young people being abused by customers is particularly perverse, balancing school and work, and denial of rest breaks. There's the stat, and it was in there. And if you think about this figure in the context that an adult has often worked for a very long period of time and had a lot more experiences throughout their career, so 47% of young people reporting that they've been sexually harassed at work. And I'll reflect on McDonald's for a moment. There's lots of reports worldwide about their international problem with the issue of sexual harassment in their workplaces. It's so much more concerning here how that is young people that are often the victims of that. We've been incredibly successful at securing money for people and compensation when they come forward, or pursuit of the perpetrators and termination of their employment. But the reluctance of people to come forward just means this is just an enormous problem. The stats are high, but the reporting is incredibly low. And there's some good examples of the kind of things that very young workers are having to deal with, particularly in fast food, where we say the matter really is untenable. And I can either read them out, but I think they're on the screen now, about the kind of examples where these are workers coming forward and reporting these things to us. Earlier this year, we conducted, it's quite a small survey, but it was a self-selecting survey of about 270 workers in South Australia, our members, and trying to understand the experiences that they face. But the South Australian Children, a Commissioner for Children and Young People, have also put together a report on some of the experiences, which I'll cover off quickly. So 30% of people say they've not been paid for work. And sometimes examples about working before and after shifts are commented on screen. 25% of people have had to work past 11 p.m. on a school night. 20% reported to us that they've had to miss school due to work. The CCYP study reported that 34% were concerned about how work clashes with study. 30% reporting that they felt pressured to work, even though they were unavailable. And again, some more examples on the screen about working past midnight and then being required to go to school the next day, or missing school because of the way they were scheduled within the workplace, having to leave early and attend work not taking no for an answer in many cases, which is all in breach of our existing law, as an aside. And again, lots of examples: skipping school for mandatory meetings, called into work when they're still at school. 25% reporting to us bullying within the workplace, and that is 10% in the CCYP study about being shouted or sworn at by a manager. Not feeling comfortable to talk to a boss or a supervisor or a manager, all rating at 20% or higher. And more reports in there about the impact that poor treatment has on young people within the workplace, and being a very high negative impact that some of these experience have. And this goes to some of the bullying examples that many of our members have faced. I won't say all of this, except that I thoroughly agreed with everything you said. I didn't call up the research because I knew you would go to it, but I do support the idea that we need better research in this space. I mean, we can pull out the small examples like we've got, but we do need a lot more work. Our union absolutely supports some kind of national minimum framework, again, whether that's through a national law or states adopting consistent legislation that deals with very clear minimum working ages that comply with the ILO Convention of hard and light work. Maximum working hours on a school day, to say that we're limited the amount of hours that people can actually do and also attend study. Maximum hours during a school week. Requirements that children do not work alone. That we introduce measures to ensure that adults undergo some form of screening to work with children. that there is more work done in the curricula to make sure that young people entering the workforce are informed of their rights and more engagement with parents for what to look out for. And that we do need to factor and do something about the economic factor, which is the junior rates of pay, and also our campaign to have super paid on every dollar, particularly for under 18s. So
Great.
thanks.
Thank you.
Cheers.
Thank you very much, both of you, because I think it's been a really useful outline of all the gaps that we're facing, both research-wise and also from a regulatory perspective. But I'm hoping Marcus can help fill in some of those gaps for us and kind of give us a story of hope.
Thank you, Tess, and thanks, Paula and Josh, for going first and second. I think it's great that you provided that, research background and the rationale for well, in your case particularly, Josh, why more is needed in most other states, and a lack of research generally to paint a clear picture and provide visibility on the incidence of children in employment across all industries, but also potentially the rates of harm that are occurring. So I think, for me, as coming from the Wage Inspectorate Victoria, where we do have the privilege to, I guess, more thoroughly regulate child employment compared to other jurisdictions, my intention is to go through and talk a bit about the brass tacks of how we regulate, but also to talk about our evolution as a regulator over the last number of years as we've moved from what was previously a permit system to a new licensing regime on the 1st of July last year. So, as a regulator, our key focus is to reduce harm. I think that phrase is really important because our focus isn't to stop all harm, prevent harm whatsoever, because it's simply not possible. I think, it can be hard to start something, and in this case, child employment regulation, and to do it as thoroughly as possible when you think that the problem is potentially too big, too amorphous, too difficult to identify and unpack, and maybe too costly. And so the alternative could be, well, you don't do anything at all, or you take too long to get there. So on that note, we commenced, and when I say we, I include our previous iterations through from before the Wage Inspectorate. I commenced in a previous or several previous iterations ago in the Wage Inspectorate at the then Employment Information and Compliance Unit in 2015. By that point, the Child Employment Act had been in Victoria, had been in place since 2004, had been operational since then. When I commenced, it was a very small unit of people. So there were approximately, I think, roughly 7 people overseeing a permit system for the employment of children in Victoria. So that was for the whole state across all industries. Combined with the previous legislation, or the previously amended form of the current legislation, trying to sort of hit every peanut with a sledgehammer in the way that permit system operated, it led to unintended consequences. So very well-meaning people working hard every day, child employment officers, regulators, to assess permit applications for the employment of children and to do what they could to prevent harm. The legislation itself, as it was then written, was very restrictive in the way that it had to be administered, interpreted and applied. And really, every time a permit was received, a child employment officer needed to assess every element and aspect of the proposed work and be satisfied that the moral, material, educational welfare of the children would be met. So that was a big ask when you're dealing with 7 people receiving, and it's been fairly stable over the years, approximately 7,000 discrete child employment permit applications every year, relating to more than 10,000 children. And of those, under the previous version of the current form of the legislation, that related to predominantly the entertainment industry. So that's just to sort of contextualise where I started and how things were, the shape of things as I commenced at the previous version of what is now the Wage Inspectorate Victoria. So what we have been trying to do as we've grown, as we've evolved as a regulator in the last really since our commissioner, as he was then director, commenced in around 2018, 2019, leading into the formation and establishment of ourselves as a statutory body from the 1st of July 2021, is to really try and go and find that information, that difficult to find research, that use a data-driven approach, use intelligence, try and use cutting edge best practice regulatory approaches to sort out, well, what have we been doing? How are we doing it now? And what do we need to do it better? I think in that context, we were very lucky as a regulator to also have obviously a supportive, interested government who was also, keen to improve child employment protections in Victoria. So that sort of leads me to reflect on, most of you or many of you may be familiar with Malcolm Sparrow's philosophy for regulation, which aligns with our recent reforms and our evolving risk-based approach, where he asks regulators globally to pick important problems, fix them, and then tell others what you did. I mean, it sounds simple, but it's obviously there's a lot going on behind the scenes to kind of reach those objectives. So in Victoria, we do, of course, have a continuing child employment regulatory regime. In Victoria, employers need a licence before a child under 15 can be employed, although there are some exemptions, such as for children employed in family businesses, but only to the extent that that involves light work. In addition to obtaining a licence, there are other important rules employers must follow, like making sure kids are supervised by someone 18 or older, who also hold a current working with children check, which goes to the issue you raised earlier, Josh, have the required rest breaks, finish work by 9 p.m. and don't work more than allowable hours. So obviously this is to make sure that their welfare, including access to education and other aspects of childhood, are actually protected. So, this is all in the context that all workplaces have risks, but as my fellow speakers have pointed out, these are magnified with children who don't have the experience, stamina or judgment of more experienced workers. So employers need to take special care to understand and manage risk to children working, and children can only complete what is referred to in legislation as light work. So, no knives in kitchens, no deep fryers, that kind of thing. No heavy lifting, bending, twisting, turning. So in determining whether any work or activity is light work or is likely to be harmful to a child's health, safety, wellbeing or development, a child employment officer at the Wage Inspectorate must consider the child's age, sex, physical and emotional development and maturity, and the nature and management of the work or activity, and the nature and environment of the workplace where the work or activity is or is to be performed. So that's what we're getting at when we're looking at a permit application. So that the journey that we've undergone in getting to this current system, it's one that has moved on from as I mentioned, a previous permit system. So I guess in that sense, and I guess how Victoria differs from the other jurisdictions, we've never, child employment regulation itself has never been the question in Victoria. When I say never, I mean since at least 2003-04, when the law came into force. But being set up now as we are as an independent statutory body demonstrates the government's recognition of the essential importance of child employment laws in Victoria. The previous permit system focused on entertainment, heavily on the entertainment industry. As I mentioned at the start, that the sector was receiving direct service. So I think really it was being over-serviced, in the sense that every single permit and every employer who approached us was given that royal gold standard of support to comply with their permit requirements. So really hitting every peanut with a sledgehammer in the context where we were dealing with mostly compliant employers, the ones who were coming to us. So that was that reactive side of a small regulator with limited resources. So we also then launched a research study. So EY Sweeney did that research and provided it in 2020. And what it told us was that our heavy focus on on the entertainment industry. So I think we were focusing almost 100% of our resources on an industry that employs around 3% of children. That needed to change, and it was disproportionate to the risk across all other industries and geographically dispersed areas. That better outcomes would result from us proactively looking for non-compliance and holding wrongdoers to account. So we needed to zoom out and look at the bigger picture, basically, from a regulatory standpoint. So we shifted that shift in focus and really that research helped to inform what is now our new licensing system. We knew that we needed a licensing system in the way that it's currently drafted to find the hidden harms and to undertake that strategic regulation. Using multiple levers such as data and intelligence, investigations, education, media, prosecutions where appropriate, and really drive that proactive work where it was most needed. So under the new system, it does that and it allows our authorised officers to focus their attention to looking for the harms and wherever possible getting ahead of them. The fast food, we might have to skip through a bit of this because I think we're a little bit short for time, aren't we? All right, just summarise a little. So under the new system, there's a requirement for assessing officers. It shifts the previous requirement for assessing officers to spend long assessment time working with employers to gain a permit to employ children, and it shifts the onus back onto the employer to demonstrate that they are a fit and proper person to employ children and will manage the risks associated with the work. So it simplifies the process of obtaining permission to employ a child by requiring one employer licence application annually for entertainment and every 2 years in general industries, rather than an employer having to apply for a permit, for every individual child for every instance. So I'm going to skip over some of that. I think it's safe to say that for the last year of and this is by way of comparison between the previous permit scheme and the new licensing scheme, for the last year of the permit scheme in the financial year 2021-2022, we had on average 335 permit applications per month, covering on average 633 instances of child employment. Whereas for the first 9 months of the new licensing regime, since 1 July last year, we've had on average 118 licence applications per month, covering about the same number of instances of child employment. So that data tells us that this change in approach from a permit per instance of employment basis for every child under the previous regime to one where a licence is issued every 1 or 2 years on the basis of the assessment of whether the applicant is fit and proper to employ a child, that's reduced the number of discrete applications by 2/3. Now, the reason that that's important and that's a good news story is because that it actually allows us to reorientate our resources and focus on getting out there and finding the harm, undertaking more investigations, putting more matters into court, more sophisticated use of media, where we can reach audiences of up to 3 million people through primetime stories on ABC and Channel 9, for example, and where through prosecutions, which have increased significantly, especially in the last 12 months. Just to paint that quick picture, with prosecutions in the 8 calendar years of child employment regulation from 2014 to 2022, there were 7 child employment prosecutions with sentencing outcomes compared to 11 since the beginning of last year. And with 10 of those being since 1 July under the new licensing regime. So that paints a really strong picture for us that our change in approach, our risk-based approach, zooming out and being smarter about how we're regulating is opening up more and more opportunities to find more harm, but also to tell that really important story to the regulated community that we're here, that we're out there, and that we will discover things and that there are outcomes and penalties if they do the wrong thing. So for the benefit of time, I will leave it at that, I think. That's a natural closing point.
Well, thank you. Thank you again to all our speakers. I might draw the seminar to a close, but really appreciate your time and your insights into this issue. If you could join me in thanking our speakers, please. And we'll be having another centre seminar on the 21st of May on pure risk prosecution. That's going to be presented by Professor Richard Johnston, and Judge Rosen will be providing comments on that. So look out for that. But thank you, everyone. Good night.